Hello, everyone. My name is Anu Murthy. I just wanted to quickly say a few words and thank everyone today for joining us. Why I started this conference, with the AI boom in the recent months, I wanted to organize a forum where we all can come together, talk about things, learn from each other, learn with each other about AI and its impact on libraries. And a huge thanks and gratitude to Georgia Tech Library for sponsoring the Zoom. Without that, we cannot do anything without Zoom these days. I'm also extremely grateful for the speakers who have generously given us their valuable time. They're all extremely busy subject matter experts, and I'm very grateful for all the help I get from my Georgia Tech colleagues today. I will not name all of them, but Heather, Martin, and Mac are they're Chris. They're all helping me today with the panel, and I finally want to thank Corey Helachik and Karen Glover, who have been giving me a lot of support to kickstart this in 4 months. So the idea came in July, and we are live here in October. And we have a registration of 1,650 registrants from 45 different countries, which 6 continents. And because we are doing this in Zoom today, we have avoided 1,181 tons of carbon emissions because we are doing this virtually. And we also, so that's awesome. And thank you, librarians, informational professionals who are joining us from all around the world. Thank you for your enthusiasm, support, and just the enthusiasm. I'm very excited. And our Dean, Dr. Leslie Sharp, will kick off the conference with a few words, and I'm going to pass it on to Dr. Sharp.
Thank you so much, Anu. Good morning, good afternoon, and probably some good evenings as well to everyone. Welcome to the first AI for Libraries conference. It is amazing to think that we have 1,650 registrants spanning 45 countries and 6 continents. Great job, Anu. The Georgia Tech Library in Atlanta, Georgia is honored to serve as a sponsor and be a part of the conference. And I am honored to have the opportunity to provide a few remarks. I want to extend a warm welcome from the Georgia Tech Library. Thank you all for coming. I also want to thank our amazing Georgia Tech e-resources librarian, Anu Murthy, who is the founder of AI for Libraries conference. She's the mastermind, visionary, and conductor behind today's events. Thank you so much, Anu, for your passion, initiative, and excellence in all that you do. I also want to thank the advisory council, who Anu has already mentioned, Corey Helachik from UT Austin and Karen Glover from Georgia Tech. And the planning committee, which includes Heather, Jeff Coate, Martin Patrick, and Anu Murthy, all from Georgia Tech. So thank you. I'm also grateful to my other Georgia Tech colleagues from the library, as well as all over campus, who have volunteered to speak, moderate, share their wisdom, attend, and support this endeavor. Thank you to all of our other speakers for your time, your energy, and your insights. I look forward to hearing what you have to say. As we all grapple with what AI means to our libraries, institutions, and to our work, it is important for us to come together to share our knowledge, experiences, anxieties, perspectives, and our dreams for the future. As we are here together, I hope that we will all take away something that will allow us to reflect and hopefully contribute to make the world a better place. Thank you all for engaging with us today, taking the time to listen, learn, and invest in yourselves as we navigate the knowns and the unknowns of artificial intelligence for our libraries and beyond. Now I'll turn it back over to Anu Murthy, the founder and coordinator who brought us all together today. Thank you again, and welcome again.
Thank you so much, Leslie. Dave Hansen will talk about copyright and AI. So I'm going to introduce our first speaker. We are so very grateful for Dave's time today. So Dave Hansen is the Executive Director of Authors Alliance, where he works to support authors on information law, policy issues, with particularly, give me 1 second, where he supports authors on information law and policy issues with particular focus on how to help maximize the reach and impact of their work to benefit the public. He's worked directly and extensively on many of the copyright issues raised by artificial intelligence and text data mining, including through briefs filed in related fair use cases and in regulatory submissions to the U.S. Copyright Office regarding text and data mining. Prior to joining Authors Alliance, Dave was an associate university librarian and lead for copyright and information policy at Duke University Libraries, where he was responsible for core research and collection support for faculty and students. He has extensive experience teaching and advising researchers, publishers, and librarians on copyright, fair use, and author's right. He has also held academic positions at University of North Carolina, Chapel Hill School of Law and University of California, Berkeley School of Law. Dave holds a JD and a master's in library science from University of North Carolina, Chapel Hill, and is a copyright attorney licensed to practice in North Carolina. We are so grateful that Dave could join us, and we are excited to welcome him. Take it away, Dave. Thank you.
Thank you so much, Anu. So let me get my screen shared because I have some slides. I hope you can see them. Yes, can I get a thumbs up?
Yes.
Good, good. All right. Well, first, before I really start, thank you so much, Anu, for organizing this. I know it was a ton of work. And when you first approached me about this, we had a little back and forth about what I would talk about. And then, you asked if I would kind of kick things off. And internally, I was thinking, like, gee, I don't know if people are going to be that interested in like the copyright stuff. But as things have progressed over the course of this last year, and as the copyright issues have sort of moved into the forefront of kind of how artificial intelligence, the future of it is going to work out in practical terms, I actually think it has a lot of relevance to libraries and to basically anybody who's interacting with different AI technologies and systems. And part of the reason why, and what I will get into in this talk, is about how copyright is actually a critical fulcrum point for whether AI will kind of continue on its path of sort of innovative new applications in a bunch of different areas, or if it will really need to be pulled back because of lawsuits. And I'll talk a little bit about the different lawsuits that are at play right now. So I'm going to talk about copyright, text data mining, and AI. And I include text data mining in here because actually I think the legal issues sort of span a spectrum of types of applications. And it's not just, ChatGPT or Stability AI or some of these other tools that have kind of come up into the front of everybody's consciousness in the last year. People have actually been doing this for a long time, or the kind of techniques related to AI for a long time under the guise of text data mining and machine learning. And so I want to talk a little bit about how those are actually common legal issues and how, from a copyright perspective, this isn't like an entirely new set of questions, which is pretty important because if you know anything about American common law, you know that when new things show up in front of the courts, they're often looking for precedent related to how have we handled these kinds of questions in the past. So I start with this slide. I just wanted to give a little comment on my background on this slide. In addition to it being a kind of interesting line drawing, I put this here because I want to flag that copyright is a really important issue for artificial intelligence and for text and data mining. But it doesn't always have to be an issue. And there are lots of applications where we can kind of clear through some of the copyright issues. So this is a image from an article that I just think is totally fascinating, mining Wikipedia data. And this is a visualization of Wikipedia editors' decisions about when to keep or delete and sometimes merge different pages. And so this is sort of a graphical representation of that decision tree about amongst editors about when to keep or delete articles. That's kind of an interesting one. And I highlight it because Wikipedia, of course, is one of those sources where we have very clean, very straightforward licensing information about what can be done with content on Wikipedia. All of it is licensed under a Creative Commons license. And so that's actually really valuable. And as you look at some of the data that has been fed into these larger training data sets, you'll see that Wikimedia data plays a really, really prominent part, as do other openly licensed sources of content. It's really fascinating to see, how significant sources like Archive or from publishers that are all open access like PLOS, how that has played out in terms of training data sets. So I wanted to give you also a little background about me. So as Anu said, I previously was at Duke University as a librarian. Actually, that's how I got to know Anu. It was a great pleasure to work with her when she was there. I'm with Authors Alliance now and as the executive director, and I realize you may not have a lot of background about Authors Alliance or like why authors would even care about this from the perspective of the legal issues, but AI has a lot of implications kind of across both the creative industries. I'm thinking about like artists and fiction writers, as well as in research and nonfiction writing applications. And I think there's a perspective amongst some authors, and I think you've seen this maybe in popular press, that authors have banded together and are sort of fearful of AI. What I'm here to tell you is there's actually lots of authors who are embracing this technology and are really excited about it. I've talked with authors who are using this to write books of poetry. I've talked with authors who are using this to ideate on different plot lines and ideas for their novels. I've also talked with authors who are using this, writers in the sciences who find this to be a fantastic tool to overcome things like language barriers, where maybe English is not their first language, but of course, in scientific publishing, basically everything is being published in English first, and so this helps them overcome some of the barriers related to having their work published in those fields. And so it's really important for authors, and I think that there are actually a lot of authors who are really excited about the possibilities of seeing this technology help them be more creative and more efficient, and get their ideas out there into the world. So if you want to find out more about Authors Alliance, we have a website. It's pretty easy to find us. We also work very, very closely with libraries. In fact, we have a library partner program that we try to collaborate with libraries on. All right, so artificial intelligence and text data mining. What can we say about this? I think it's important to start off with a handful of definitions. I am not a technical expert, but I do have some understanding of kind of the different tools that are being used, kind of different definitional terms, and I think it's important to start off there. So text data mining, for those of you who are unfamiliar, automated analytical techniques aimed at analyzing digital text and data, looking really for patterns, trends, correlations. And so, so text data mining, often you're looking at a corpus of materials and then trying to find patterns and understand what's going on within kind of that limited corpus. Artificial intelligence is something a little bit different, but raises some related legal issues. So AI is where we're looking at computer systems or software that can perform tasks that are typically requiring human intelligence. And that includes some of those things like recognizing patterns and problem solving, but at kind of a higher level and using corpora in a different way. Training on corpora, particularly like large language models, training on those not necessarily to understand that corpus, but to use that corpus to understand other things. So, why do we do this? I think particularly for text data mining, for AI, the answer is pretty obvious. It's that, we want to be more efficient. We want to be, we want to, enable new uses where perhaps the individual who is using that technology isn't able to do it quite as fast or quite as efficiently. For text data mining, I think that the why of it is also pretty classic research answer, right? Is we want to discover new things. And when we're looking across a large corpus of works, there are limits to what humans can do. If you want to understand language patterns across a corpus of 2,000 books, it's really hard to sit down and read 2,000 books and analyze them yourself, but it's not easy, but it's doable to take those books, digitize them or obtain them in digital formats, and then use computers to help us kind of sort through what the patterns are within those works. So, in terms of application, we see this across a variety of different fields. And I know we're going to hear later in the day as part of the program some of the different interesting applications of AI, and kind of related text data mining, machine learning uses. But I just wanted to highlight a few to give you a sense of kind of the disciplinary span. And so, here's an article, pretty interesting one from actually quite a long time ago in technology terms, from May 2005, looking at text mining for identifying metabolic pathways. And this kind of health research and biological science research has advanced significantly since then, using a lot of data and text mining techniques. You also see this used in the social sciences. This is a really interesting article from just a few years back, looking at body cam footage from the Oakland Police Department and assessing how officers treat suspects or other individuals that they interact with based on their race, and using a very, very large and pretty rich corpus of body cam footage. We also see people using this to analyze popular culture and to look across audio and audiovisual works. And so there's a really interesting lab at the University of Richmond called the Distant Viewing Lab. And they're looking at a variety of these things. The top left corner is an analysis kind of looking at character representation in a couple of pretty probably familiar TV shows from the 1960s, I Dream of Jeannie and Bewitched. And you might, want to understand that a little bit more to understand kind of cultural consciousness about representation of characters and things. So lots of applications. I wanted to call out, and one of my favorite projects is actually a project that Quinn Dombrowski at Stanford University has done a lot of work on. It's called the Data Sitters Club. And they're using these kinds of techniques to more deeply understand a set of books that you might be thinking like, oh, why would anyone analyze that? But there's actually a lot of interesting things to learn from looking at some of the books from the Babysitters Club. So check out their website. It's kind of an interesting exploration, not just in the text and data mining side of things, but also talking about some of the how-to of how you actually go about doing that kind of analysis on that sort of corpus, including some posts like this one on how to address some of the legal issues. So turning more to AI, one of the things that we see with AI, all those examples that I just talked about in the text mining, text and data mining space are focused on kind of relatively controlled and relatively well-defined corpora of materials, right? Where you're really studying that corpus to understand patterns within it. For artificial intelligence, one of the things that, and I won't go through the whole sort of technology stack and the pathway of how we go from content, whatever it is out there typically on the internet, and how that feeds into training like a large language model. But one important facet of this that I think many of us appreciate is that in order to train those models, many of them have relied on very large corpora of diverse texts in order to build out those large language models. And so, that has come with certain degrees of controversy. So where in the text and data mining space, we may be looking at, someone taking a corpus of maybe a few thousand works. Here we're talking about like multiple millions. And so this is one of the more controversial ones, the pile, 825 gigs of an English text corpus targeted at training large language models. And this is actually compiled from 22 other different, what they are defining as high quality subsets. And you can see the list of where they are pulling this from down in the bottom right-hand corner, being pulled from PubMed Central, Archive, GitHub, Freelaw, US Patent and Trademark Office, Hacker News, YouTube. It's really from all over the place. And some interesting other features in there, for instance, at the bottom, you'll notice they also pull from some other existing data sets like Books 3, which is super controversial because it includes lots of in-copyright books. It includes English Wikipedia, which is a huge source, and many data sets that have been used to train LLMs pull from that. But it gets kind of interesting to see these different spheres that are needed to build out a quality model. Like, for example, they also pull from the Enron emails, which is sort of unique in that we have maybe one of the more open and transparent sets of kind of corporate emails coming out of the whole Enron series of lawsuits and investigations. And so that's actually a very helpful source for just understanding like how humans talk to each other in that context. So I want to talk about how copyright fits together with all of this. And we basically have three big questions that are staring us in the face when we're trying to understand how the law fits together with artificial intelligence. So before we get there, though, I think it's helpful to start with a few basics, at least in the United States. And I realize we have people from all over the world, and the legal framework around the world does differ a little bit. But I want to start with the United States because this is where a lot of the legal action is happening right now, particularly in terms of litigation. There's some other interesting legislative efforts in the EU happening with the proposed AI Act, but I don't think we'll have enough time to get too deep into that. And also, it doesn't touch on copyright as much as it does other issues. So copyright in the US, some basic things that are important to know. One is copyright is designed to promote the progress of science and the useful arts. That's the purpose of copyright. It's not about protecting publishers' bottom line. It's not about making sure that authors are set for life. It's not about protecting some sort of moral imperative or moral right related to a creation that you might have made. The whole system is instead aimed at promoting the progress of science and the useful arts by providing this limited set of protections for authors and inventors. And the idea there is we're going to give them protection that they can then, use as a bargaining tool to get paid for their work. And if they can get paid for their work, then they will create more stuff, and that will be good for society. That framework has some important limitations on it. So for one, right, copyright doesn't last forever. We know that. That's why it says for limited times. Although it does last for a very long time. Congress has extended copyright to be, at least in the United States right now, it lasts for the life of the author plus 70 years, which is a tremendous amount of time. You could have copyright protection for, over a century there. Whoops. So a couple other limitations that are really important in this context are copyright protects original works of authorship. That is, you have to have something new, and it has to be something creative. That's how the courts have interpreted authorship, right? Authorship implies creativity. And so it can't be a pre-existing fact. It can't be an idea. And in fact, Congress has codified this down below the very last quote here at the bottom. In no case does copyright protection extend to an idea, procedure, process, method of operation, concept, etc. Those are really important limits, because from a free speech perspective, it's one thing to say you get protection over this particular way of saying things. It's another to say you get to control that idea or that fact. And copyright does not do that. So when we think about text and data mining or artificial intelligence, I think it's really important to hone in on that negative space that copyright provides, where there is not protection because of those limits on control over facts and ideas. Copyright also provides these broad exclusive rights. So with that limitation in mind, that you can't control facts and ideas, you can control expression. And so over your expression, you actually have very broad rights as a copyright owner. You have the right to control reproduction of that work, like basic copying. Right to control creation of derivative works, right? So like maybe I wrote a novel and I want to turn it into a movie, right? I would get the right to control that and to distribute, perform, and display copies publicly. So that's sort of copyright 101, copyright basics. So now we're going to get into how does all of this fit together with artificial intelligence? So we have these three big questions. And the biggest of the big questions is number one. Is it permissible to use copyrighted works used as for use as training data? This is really critical because some of the largest models that we have, or the most robust models that we have, are based on very, very large data sets that include a wide variety of copyrighted works. And if it is not permissible, and it turns out those are infringing activities, that could radically change the landscape of what kind of AI technologies are available, how much they cost, what kind of applications they might be used for. So that's like point number one and the biggest thing. The second two questions are interesting, but maybe not as earth-shattering. So, second is, okay, you have AI outputs coming from certain works or certain systems. And what is the status of those? On the one hand, are they infringing themselves? And in what circumstances? And if so, who's responsible for that infringement? And then the third question is, are they actually protected by copyright? What sort of rights do you get over that content that comes out the other end? So I want to spend most of the time talking about this first question because it's so critical. And it's a majorly contested one. And so just to give you a sense of how contested, over the last year, we've seen a large number of lawsuits filed. So almost exactly a year ago, we saw really one of the first really big lawsuits filed. This was against GitHub and Microsoft for their Copilot service. So if you go into GitHub, it has this Copilot service that will sort of suggest particular code language for you to use, drawing from the corpus that GitHub has, and it's in the base of code that has been contributed there. So this case was filed as a class action. It actually didn't make direct copyright infringement claims because so much of the content on GitHub is licensed under open and permissive licenses. But it made a lot of claims related to copyright management information. One of the things that you'll find in the law is it says that you can't, for example, strip out copyright metadata from works. And so that was the basis of the claim there. So that was the first one. And that was a big deal when it was filed. Then we saw a few months later in January of 2023, a class action against Stability AI. And this was dealing with image generation, and the basis of the claim here was that Stability was relying on and training its models on data sets that included artists and other graphic creators' works. And they claim that merely use as training data was infringement. Then we got another one based on images, and this was from Getty, basically making the same thing, although not from the creator standpoint, but from the standpoint of Getty, which owns a large number of works, or copyright in a large number of works, and they claim that Stability was using those as training data in an infringing way for its products. So then we got another class action, this one against OpenAI, basically focused on ChatGPT, and saying, hey, you're using the works of authors, creators of text, to train your systems, or to train the models that your systems are relying on, and that's infringing. So then we got another one in July. Sarah Silverman brought another one based on authors against OpenAI. And then we got another one, this one against Meta, similar claims. Sarah Silverman and others are also there. And then we got another one. And this one was in September against OpenAI, again, another author suit. And then we got another one, this one against Meta. And then we got another one, this one brought by the Authors Guild and a number of authors, David Baldacci, and other names that you probably recognize there. And then actually, so I made these slides, I last updated them yesterday, and since then there are 2 more lawsuits. So the newest focused on the music industry. And I wish I could have been able to put those in here, because it's essentially the entire music industry banding together and suing a couple of AI music systems. So so this is like a highly contested thing, lots of issues in the courts right now, and lots to pay attention to here. So to kind of reframe this first copyright question, the basis of all of those suits is kind of asking, how can it possibly be okay to copy thousands or millions of works as training data? And this might seem like, whoa, that seems crazy. How could you possibly do that? Yeah, that seems like an obvious copyright problem. But actually, we have a number of cases that have dealt with this in the past. And what they've done is they said, yes, copyright owners get to control their expression. They have broad exclusive rights, but there are limits on those rights. And fair use is that really, really important limit that libraries and archives and museums and educational institutions rely on heavily, but so does industry, actually. And I think that often gets left out. A lot of times we hone in on this highlighted part about teaching and scholarship and research, but actually fair use is a really critical part of the technology sector and online innovation in the US. So fair use doesn't exactly tell you what you're allowed or not allowed to do. It just says, and if you read it, it's a little bit like frustrating. The first sentence says, notwithstanding the provisions of Section 106, which are those exclusive rights that I read off to you before, says the fair use of a copyrighted work is not an infringement of copyright. Okay, so it's not an infringement, but you're not telling us what fair use is. It gives us some examples. It says criticism, comment, news reporting, etc. And it says, you know, that those things aren't exclusive. Those are just some examples. But then it asks us to focus in on these 4 factors that we're supposed to balance together. And so I'll talk through these 4 factors just so you get a sense of what this is about. Number 1, purpose of the use. So what we're looking for here is essentially like, is the use substituting for the original, or are you doing something new and transformative with the thing that you've done with that work? And so, you know, I think the classic example is parody. Like many of you may have heard of a case called Campbell v. Acuff Rose. This went up to the Supreme Court. It was about the rap group 2 Live Crew and how they had taken Roy Orbison's song "Oh Pretty Woman" and they created essentially a parody of it. And so they were using sort of the basic lyrics and, you know, some musical themes from the original, but they were making fun of it. They were doing something new and different. And so clearly you could see there that it's not a substitute. No one is going to say, well, I could have bought a copy of Roy Orbison's original, but instead I'm going to buy this copy of a different song that's making fun of it. Like, that is not a substitute at all. It's fulfilling a totally different market function. Second thing that courts look at is the nature of the original. And this is where this factor actually doesn't get a whole lot of emphasis placed on it. But the idea here is that copyright protects things that are highly creative, and things that are kind of minimally creative maybe don't get as much protection. And so that's like an important facet. The third, and this is where a lot of people hone in on for fair use, is that the courts want to look at how much you're taking and how substantial that is. So, you know, if you took 90% of a work and reuse that 90%, that's a lot different than, you know, maybe you quoted a couple sentences or a paragraph from somebody's book or article. And then the fourth, and a lot of the analysis comes down to this, is what's the market effect? And that market effect is sort of tricky when you start thinking about it. But what you want to look at is, how is your use affecting the market for the original work within the copyright relevant market? So for example, to take the parody example, right? If you make a parody and you like totally eviscerate the original and you make fun of it and everybody's like, yeah, that original is really stupid, and you negatively impact the market, that's not the kind of market control that copyright owners get. However, if you go in and you don't create a parody, you just create like a knockoff version and everybody's buying your version instead of the original, that is the kind of market effect that the law cares about. So how does this apply in a situation where, you know, you're not creating a parody, you're not creating like, you know, a criticism or commentary, but you're just like mass reusing works? Well, we actually have a couple of really important precedents on this from a few years ago. The first was the Google Books case, and the second was the Hadi Trust case. These are 2 related cases where basically a number of very large university libraries struck a deal with Google and said, hey, we will allow you to digitize massive parts of our collections, millions of books, not so you can provide like full text access, but so that you can provide search functionality, and you can provide some kind of interesting text and data mining type uses. They also had some other reasons for doing it: preservation, access for print disabled users. But that was those first 2 are the things that I really want to focus on right now. And so, and I want to flag here too that the court actually had these sort of text data mining analytical uses in front of them. Both the parties in those cases talked about it, but you actually had digital humanities scholars making the case to the court that these types of uses should be allowed because they allow for analytics and pattern recognition across corpora in ways that are totally transformative and new and different from what the original works were created for. And so what did the court say? The court said that these were highly transformative new purposes. They didn't match up with the original. So when you write a book, you write it so that people will buy your book and read it. And in this context, you weren't, writing that book so that someone could do a text search across it to see if it's relevant. You didn't write that book so that someone could analyze the language in your book, kind of extract facts and information about like which adverbs did you use or how many times did you use certain pronouns. But others can do that and go in and kind of extract that information. So that kind of use is actually highly transformative. It's a totally new purpose. And so that's favored under the law. And again, this was being done across millions of works. Second is nature of the original. That was not a very important factor here because you're talking about kind of aggregate collections of millions of works. And so it's just frankly hard to analyze that at that level. So the court didn't place much emphasis on that. The amount and substantiality. Although the entirety of the work was being copied, the court said, yeah, but you're not like exposing the entirety of the work. What you're doing is you're showing people, in Google's case, small snippet views. When they do a text search, they'll get like a couple lines back. And that kind of use is appropriate given the purpose. And then finally, at market effect, again, this kind of gets down to this is something new and different from what the original work was intended for. They're not competing substitutes, right? Like no one is going to say, I would have bought that book, but instead I'm going to go, use Google's book search to kind of cobble together this book using like these little search excerpts. In fact, the plaintiffs in that case had an expert actually sit down and do that. And it was kind of comical to read like how long it took them to recreate the book in a way that you could actually consume it. So one thing the court did care about was security because they did worry about, if you have this corpus, how is that going to affect the market if it kind of leaks out to the world? So, in addition to those cases, there's other legal support for this idea that you can copy large numbers of works and use them for analytical purposes, for text and data mining. The Copyright Office has actually weighed in and granted an exemption that Authors Alliance petitioned for with the Library Copyright Alliance and AAUP. So they've said, at least within the research context, they believe this is fair use. But those cases don't answer everything. So the big open question here is, well, what about when you're not just doing this for search and analysis, but also using it, using these systems in a way that will create new works like generative AI, when you've got, a novel being fed in, and then on the other side, a novel comes out that is different, but used some of the information from the underlying work. Now, if you're familiar with the way that these systems work, it doesn't seem to be that the right analysis is what comes out the other end. It's what is the system, right? And is the system fulfilling a different purpose than that original work? And I think it's clear that it is. Again, it also doesn't address this issue of how should we think about these systems that are used by users to create new works. So that's sort of the fair use landscape for training data. You could see that with all those lawsuits, there's a lot of potential there for issues to arise where if the answer to those questions is no, fair use doesn't apply, that could significantly impact, for instance, whether libraries are able to make their digital collections available as training data for AI, which actually could have some interesting implications for maybe improving some of the quality of answers that comes out in some of these systems. So that's what we're dealing with. I think over the next year or so, we will have some answers. I guess I will also plug here, the Copyright Office is currently doing an inquiry about, trying to get a sense of what the public thinks about copyright and AI. Comments are due on October 30th. So, if you have some time and you have thoughts, you can weigh in. Just go to copyright.gov. It's really easy to find. All right, so second question. This one is actually, I think, relatively simple. Are AI outputs infringing? And if so, who is responsible? So for copyright, it's important to understand there are a few different pathways to liability for infringement. Number one is you can directly infringe someone's work. That is, you make a substantially similar copy of someone else's work, and fair use, et cetera, doesn't apply, right? So the most straightforward example is I just photocopy a book, right? And then I distribute it out to the world. That's really easy. there are these other types of infringement that come into play as well. So they're known as contributory infringement and vicarious infringement. And basically, what's required there is, number one, somebody else has done some direct infringement, but then you either knew about it and kind of induced or contributed to their infringement, or you profited off of it and you had the ability to control it. So like for vicarious infringement, the classic cases on that are people who operated flea markets and invited others in who they knew were selling bootleg DVDs, and they profited because they were getting kind of a cut based on, you know, the vendor's fee to be located there. So those are the different pathways to liability. We've seen these come up in some cases over the last, remember Blast from the Past, 10 or 15 years ago, in cases involving Grokster and Napster, because of course Grokster and Napster weren't directly copying, you know, anybody's music or DVDs, but they were facilitating that infringement. And in those cases, the courts said, yeah, like basically your entire service is used just for this purpose of infringement. And so while you may not be directly infringing, you're contributorily and vicariously infringing, and so you're responsible. So for AI outputs, one of the issues that we run into is certainly you can use these systems for a wide variety of non-infringing uses where the outputs look very different from any of the inputs. But you can also use them you can direct them to create outputs that are very similar to known copyrighted works. So there's a law professor at Emory who writes a lot about this, Matt Sag, and he has a really interesting paper about generative AI and copyright safety. And so he talks about the Snoopy problem, right? Of like, if I ask so I went into Midjourney and I said, draw me some pictures of Snoopy at a computer, right? And the Snoopy problem is, of course, if I ask it to draw a picture of Snoopy, it'll draw me a picture of Snoopy. And Snoopy is this kind of known copyrighted character. And so one of the issues here is how much are these systems designed to prevent obviously infringing uses, right? And so what kind of filters do they have in place? What sort of best practices do they follow to prevent this kind of output? And I think for libraries and for higher education, this can be a really important thing to think about, not just in terms of are the systems that you're using okay, but what sort of outputs are you using that for, and what sort of applications, and what do those outputs look like? Like you have to separately assess if there's infringement there. So we don't know how this is going to work out. I think that will be actually a major feature in those lawsuits, is to what extent are these systems responsible for the creations that users make using those systems, and what responsibility do they have to sort of filter some of that content. Finally, are AI outputs protected by copyright? And I'll try to make this pretty quick. Again, remember this, I quoted this before, copyright protects original works of authorship. And the courts have actually been pretty clear. In fact, many of you may remember this case made a lot of news a few years ago. Harambe, there was this I always call it a monkey. It's not a monkey, it's some sort of other primate, but photographer put his camera down, let this fellow pick it up and take a selfie. And the question was there copyright protection over it? Because it wasn't the photographer who took the picture, it was Harambe. And it actually went up to the Ninth Circuit Court of Appeals, and the court said, no, to be an author, which is required for copyright, you have to be human. And so that has been sort of the baseline that the courts and the Copyright Office have, and there's lots of agreement about this. And so the Copyright Office has encountered this a few times. This is a pretty prominent work that was AI generated and submitted to the office for copyright registration, and the office refused it because it was entirely AI generated. And so, you know, so far the answer has been no copyright protection. There's also been a lawsuit about this that the Copyright Office won. So the courts have agreed that, like, if it's solely computer generated work, there's no copyright protection. So I do want to say that there's, a little bit of nuance there. What happens when you have AI generated work mixed with human authorship is kind of an open question, and that I think is going to need to be resolved in the courts. So what does this mean for libraries? A couple of things related to text and data mining. Not everything is protected by copyright. I think that's important. Not everything needs to rely on fair use. Fair use is important, but you can get permission in lots of cases. In lots of cases, lots of data sets are already openly licensed, like Wikipedia, which I mentioned before. And at least for text and data mining, I think that we can feel very comfortable supporting researchers in that space because of Google Books and HathiTrust and the Copyright Office's exemption that they've granted. And so research applications with text and data mining actually seem very safe. For generative AI, we have a big question about the viability of large language models because they kind of take that aggregation and transformative use to a next step where they're actually producing outputs that look in some ways similar to the inputs. Those cases are really big. They're kind of make or break for, I think, actually a lot of the industry. It would dramatically alter the shape of that industry if those cases concluded that fair use doesn't apply. I think the case law provides strong support, but it's not entirely certain. And so that's why these lawsuits are important to follow. And so, taking it down to library applications. So for example, I've heard of some folks using this for creating metadata or for translating subtitles on audiovisual collections or other things that really enhance access and discovery. There are some copyright implications. I think some of the big ones are, what sort of protection do you get over that content that you've created? And for the most part, I think the answers are not much, although maybe that's good. Maybe that's, a lot of us really want to see metadata free and openly available without a lot of copyright strings attached. And so that could actually be a good thing. But I think the other side of it is we want to think carefully about how much we invest and build our systems around existing AI tools as we wait for the law to kind of clear up in these different areas. All right, so I would like to see if there are some questions in the chat or in the Q&A, and I know I've only got about 5 minutes, but let's see here. Yeah, so does the fact that some generative AI services have started to charge for the service interact with fair use? Yes, and that's a really important feature and actually something that I think is going to get played out in these cases. So one of the things that courts have emphasized over the years is that commerciality is actually an important feature of whether something is fair use or not. And so, if there's kind of a nonprofit, non-commercial actor who is creating a large language model and using that to set up a system that's kind of in the public interest, that looks a lot different than someone who is building a profit generating service. And so charging actually could have an impact on those cases. And for libraries, actually, I think that's really important in that libraries have felt, for the most part, kind of insulated or kind of extra protected by fair use because of that commerciality inquiry. That perception, I think, was a little bit challenged recently in the Hachette versus Internet Archive case, which many of you may have heard of, about controlled digital lending. Because in that case, even though the Internet Archive is totally nonprofit, they don't charge anybody for anything related to access. The court said, well, yeah, but you're driving all this traffic to your website, and you're getting more donations, and therefore this looks commercial to me. And we'll see how that works out on appeal. I think that's a really weird definition of commerciality. If that's the definition, then like the vast majority of things that libraries do would fall into the commercial bucket. And that just doesn't make sense. So I want to see if there are any other questions. Oh, here's a good one. I have a bunch of researchers wanting to bulk upload PDFs into AI to do meta research. It sounds like this is potentially a safe use. I was a little nervous about the use of the data afterwards because it's unclear how ChatGPT is then using the data. our users would not need to worry about it because they're using it appropriately. Yeah, so actually there's another aspect of all of this that I think is important to talk about that's a little bit outside of copyright, which is your use might be okay from a copyright standpoint. If researchers are want to use these systems to kind of interrogate PDFs across maybe a small corpus that they've created and learn more about it, I think fair use, especially for nonprofit research, would generally support that. A challenge, though, is it's not just copyright that's at play. When you enter content into ChatGPT, you also have to contend with the ChatGPT terms of service. And those terms of service may say things like that OpenAI and ChatGPT can do other stuff with the content you've uploaded, and that could be a problem. And so it's really important always to read terms of service. And there are some emerging other services that are a little bit more research oriented that have better terms. This is actually something where I think libraries are going to play an important part for their research communities at academic libraries, where I think increasingly you're going to be asked to be involved with license negotiation to make sure that research related AI systems that are available to campuses have terms of service that are appropriate, that protect intellectual property, that protect student privacy, that protect research integrity. And so I think that's kind of an emerging new area that for those of you licensing librarians on the call, I think it's smart to start thinking about, like, what are those important terms and what would that look like? I think I have time for maybe one more if I do it quick. So this last one is about basically queries made to these systems, prompts, right? So AI created products are created by initial human inquiry. Can the human who made the initial inquiry then claim some copyright over the product? So this is tough because there's a certain amount of kind of randomness in the output, no matter how specific your prompt is. And so far the answer has been no, but you can claim copyright over that sophisticated prompt. And some of these prompts, I don't know, like a lot of us who play around with these systems put in like a 10-word prompt or a 5-word prompt, but people who are really sophisticated using them may be putting in 1,000 words describing what they want with a lot of creativity and specificity. And so certainly that prompt can get copyright protection. All right, it is 10 o'clock, and I know that there is like a lot of other stuff to talk about. I hope that this was a helpful kind of overview of some of the copyright issues. And I'd love to hear from folks, separately offline. I put my contact info up. Feel free to email me or tweet me or whatever that's called now. And I'd love to hear more from you about this. Thank you so much, Anu.
Thank you so much, Dave. Once again, we are extremely grateful for generously giving us your time and expertise. Thanks, Dave.
Thank you to Dave. And with that, we are going to wrap up this session. We are now on a break from 10 to 10:10, at which point we will be coming back for our next panel, which is entitled AI Libraries and Higher Education. And that will run from 10:10 to 11:10. So we will be back in 9 minutes at 10:10 for our next panel.